Good afternoon to all those attending the public hearing of today of the Vetting Commission, established under the law number 65 on the external evaluation of judges and candidates for the position of judge of the Supreme Court of Justice. I am Andrei Bivol. I am the Deputy Chair of the Commission and Chair of the Panel C, and I declare this session open. Now, this hearing is carried out on the basis of the law number 252 of 2023 on the external evaluation of judges and prosecutors, and on the basis of the rules of procedure of the Commission. Now, the subject of today's hearing is Mr. Radu Țurcanu, judge at the Chișinău Court. From 2017 through 2021, Mr. Țurcanu was the president of the Chișinău Court. Welcome, Mr. Țurcanu. Good afternoon. Good to be here. With me here, there are the two other members of the Panel C. To my left, Madam Larry Perling, and to my right, Mr. Willem Brouwer. Now, this panel is also assisted by members of the Secretariat. Behind you, there are representatives of the mass media and of the public, and also we have a photographer here who will be taking pictures in the first few minutes of the hearing. There is simultaneous interpretation between Romanian and English to allow for accurate interpretation. I would like to ask everyone to speak clearly and one at a time. The hearing is being recorded, and the recorded parts shall be made available on the website of the Commission, www.vettingmd.eu, within 3 days after the hearing. I will briefly describe the evaluation procedure applied to Mr. Țurcanu. The Commission initiated it on the 2nd of May 2025 by notifying Mr. Țurcanu by email, and he was also asked to fill out and return the questionnaire and the declarations provided for in the Law 252, and Mr. Țurcanu did so on the 21st of May 2025. On the 30th of May 2025, according to Article 37, paragraph 3 of the regulation of the Commission, Mr. Țurcanu was informed about the fact that his case was randomly allocated to the Panel A. Now, the subject was also was duly informed about his right to provide a reasoned request of recusal if he believed that that was required. To this date, an application in this regard has not been filed. On the 20th of August 2025, Mr. Țurcanu was advised about the change of the name of the panel, and it became the Panel C. During the evaluation, the Commission obtains information from a number of sources, such as the NIA, the SDS, the General Inspectorate of the Border Police, other public institutions, financial institutions, and is also looking up information of the sources. The Commission assesses the information it obtains in terms of relevance and reliability. From the 30th of June 2025 through 9th of October 2025, the Commission asked Mr. Țurcanu to provide additional information to shed more light and clarify several aspects, and that was done as part of 3 rounds of questions, and the subject observed the deadlines. On the 24th of October 2025, the Commission notified Mr. Țurcanu about having finalized the evaluation and about having identified certain doubts with regards to the observance of the ethical and financial integrity criteria, and has invited the subject to participate in today's hearing. On the 26th of October 2025, Mr. Țurcanu has confirmed with the Commission that he would attend today's hearing, and he has asked for access to the evaluation materials, and he was granted this access on the 28th of October 2025. That is after having returned the notification on the access to materials and the non-disclosure agreement. Now, your answers to the Commission and the information that you provided in the 5-year declaration and in the ethics questionnaire that you have sent to the Commission on the 21st of May 2025, is that still currently topical and accurate? Yes, that is indeed the case. Next, the members of the panel shall ask you questions regarding the information that was also addressed in the notice of hearing. We'll try to formulate our questions in a brief, clear way, so also please do follow the same spirit in providing your answers to the questions. Now, Madam Perling will be the one who will start asking you questions, and that will be making additions to that as we will see fit.
Thank you. And good afternoon, Mr. Țurcanu. I would like to clarify some aspects in 2 big issues. First of all, inexplicable wealth. And if I say inexplicable wealth, I talk about years 2015, 2016, 2018, and 2023. And the second big issue is, let's say, ethical issues. We talk about the issue regarding allocation and redistribution of COVID allowances and the issue regarding the salary supplements. Is it clear for you, yeah? We don't repeat the questions, but let's start from the very beginning. For general, it's important to mention that the Commission has found that negative balance between your income and outcome is minus 725,630 leis. That means that your family, by our calculation, and your close family members had expenses that exceeded your income in this amount. And now let's take year by year. Let's start with the year 2015. And we would like to talk about the two private loans. According to Commission analysis, you know that in 2015 you reported full repayment of two loans, 150,000 plus 100,000. And we talk about loans which before had reported as income sources in 2014. And when we asked during the third round of questions to provide explanation, when you said that and these amounts do not constitute current consumer expenses but rather repayments of debts previously recorded on the basis of loans received in 2014. And you added that therefore the 2015 repayment represents a simple accounting outflow of liabilities, not a consumptive expense. And now my first question is, and this is very simple, did the money move as you described when you took the loan and you repaid it back?
Yeah, members of the Commission, regarding this statement about the existence of a negative balance, according to the findings of the Commission, of 12,918 lei for 2015, I will present the following clarifications, which prove that this discrepancy is an apparent one, and it results from an error of classification of the financial flows rather than unjustified wealth based on the law. First of all, I'd like to draw your attention on the real nature of the flows, repayments of loans rather than consumption expenses. Indeed, as you, Mrs. Lovely, said, in 2015, I reimbursed 150,000 and 100,000 to their relatives, close relatives. And these loans were taken in 2014 and were declared, analyzed, and reflected already in the flows for that year, for that respective year, being designed for paying the apartment on that indicated street. As a result, the reimbursement in 2015 represents extinguishing an obligation, a liability, and doesn't represent a consumption expense. In this sense, I am convinced that the situation of the cash flow and also the national accounting standards and the provisions of Article 187 Civil Code stipulates that the reimbursing loan is a neutral flow without having an impact on the real wealth. And the classification of this reimbursement to current expenses has generated a negative balance, obviously. And the real flows for covering are the savings in 2013 and 2014. The reimbursements were covered exclusively from the savings of my family gathered during 2013 and 14, which weren't consumed after the repayment of installment of the apartment, as well as from other legal and declared incomes. At the same time, in 2014, at the end of the year, particularly on the 31st, on the 10th month, 2014, which stems from the integrity declaration, wealth and integrity declaration filed with ANI, I benefited from an additional revenue of 1,100 euro as being a member of the Consultative Council of the European Judges from the CEPEJ in Strasbourg, which represents an inflow treated according to the methodology of the Commission as the outgoing flow for 2014 and incoming flow for 2015. Or this amount wasn't included by the Commission, although it contributes to eliminating that apparently negative balance. Finally, I would like to retain the attention of the Commission that the real entries for 2015 are not limited to just the salaries, but they include some other financial earlier reserves, which are perfectly legal and documented.
Thank you. I just repeat my simple question. We talk about the loans, and my question is, what about the money? Did the money moved as you described when you took the loans and when you paid them back? Very simple, yes or no answer.
No.
You took loan 2014 from your brother and from another person, and then you paid back. Is it real or no?
Da. Dacă îmi permiteți, am să fiu foarte succint în partea ce se
I will be very short about the flow of this money. In 2014, I concluded an agreement with the developer which built real estate at a preferential price for the judges and the civil servants in the system. According to the installments and the payment order, these amounts had to be paid in 2014, 15, 16, 17. Originally, it wasn't established any hierarchy or any schedule for payment. That's why, in order to make sure, because I had some savings from the previous years, and to make sure that I have full coverage for that amount, I made these borrowings. Therefore, during the following year, based on the savings I had, I repaid the loan. With regards to the lawfulness of this borrowing, this was under private signature because I took these funds from relatives.
Thank you. I just ask, please be shorter because we already have several answers from written rounds. The next question, were the repayments made? If you say you made the repayments in cash or through the bank transfers?
Payments towards whom?
Payments of loans.
Well, the payment for the loans or repayment of the loan, well, so the repayment was done in cash to the relatives mentioned in the explanation in year 2015 because I received those funds in cash. Therefore, I reimbursed them in cash.
Okay, and if it was in cash, then what kind of money it was? What was the origin of the money?
Da, originea banului era valută.
Well, the origin was national currency, because all the transactions in Moldova are done in Moldovan lei.
Currency. I mean, what is the origin of the money? Where the money came from? It was cash, savings, your salary? What kind of money it was?
Da, am să vă răspund.
I will answer this question. I'd like to say that during this period, no major or important substantial expenses were incurred until 2014 and 15 by my family. I didn't have any procurements of houses, real estate, land for construction or agriculture. So the only savings were based on salaries and other incomes that I had during the reference period until 2015.
If we talk about repayments, 50,000. Do you remember what was your salary in 2015?
According to the information presented by the Commission in 2015, my salary was 173,217 lei, the main service being a judge at the Chișinău Court. And also as a university professor lecturer, I was a teacher within the Academy of Economics Studies, and I had over 40,000 Moldovan lei. And last but not least, I was a trainer with NIJ, and I had a salary of 1,231 lei. These are the declared salaries, salaries declared by me to NIA, Integrity Authority, which has confirmed that.
Yes, that means that 50,000, it was significant amount compared to your annual income. Could you please very shortly explain how you managed to meet with the financial obligations without exceeding your available legal financial resources? How it was just possible?
It was possible based on the savings of my family, of my household during the years before 2014, at the end of 2014 and beginning of 2015. I'm speaking about 2010, 11, 12, 13, including 14, where we didn't have capital investments, and we made savings from salaries and other incomes. And also I worked as a teacher during that period of time, and I had additional salaries, other salaries than the basic judge salary.
And from what period savings you talk about?
From years 2010 to 2014.
Thank you. Let's take the year 2016. Here we talk about balance 143,000, and here we would like to talk about installment payments to apartment located Romana Street. Because in 2016 you reported 2 installment payments for acquisition of an apartment. And we talk about 114 square meters apartment. And here we would like to understand, please tell us what kind of source of funds you use to make the payments. Again, considering your total annual income in 2016 was so much lower than your outgoing financial flows.
Thank you very much for the opportunity to explain this. During 2016, so as regards the preliminary finding, the difference of 143,066 lei for year 2016, allow me to present the following clarifications, which in my opinion and my position prove that this is the interpretation of the financial flows does not reflect the economic reality of the funds of my family. As you noticed, the payments to the developer which built that real estate And indeed, the installments paid in 2016 were covered based on from the balance remained from the loans taken in 2014 to pay this property, the savings which weren't consumed for year 2015, including 2016, salary savings from 2014 and 15, as well as contributions of my wife, which had her legal incomes reported, which were reported. Or these amounts existed at the beginning of 2016, and they had already been declared, reported earlier towards the Integrity Authority. The justifying documents are the investment contract in 2014, second, the bank excerpts for the installment payments, and the other records submitted by me to the Commission. And as a remark, since you asked me about the area of the apartment, I declared and I presented pertinent proof, evidence that according to the initial report of the developer, there was an area of an apartment, but when it was commissioned in the end, because there was an adjacent terrace, this included the terrace. Therefore, this terrace was included, which led to increasing the size. So originally it was 89 square meters, and then after the commissioning, but after it was commissioned and the terrace was included, the amount went up to 114.
Thank you. Can you talk about savings? From what kind of period savings you talk about?
2014, 2015, 2016.
No. You talk about now year 2016. So the saving should come from previous year.
2014, 2015. 2014,
okay,
2015.
But as I understand, you declared in the beginning of 2014 unsubstantial savings. That means that very small amount savings. How you explain it?
I will explain, dear lady, Honorable Commission. According to the statement about property and income made towards the Integrity Authority, I declared the amount of 148,218 lei as salary income.
Sorry, my question is, have you declared all your savings or no? Because if we look at your declaration, there are no that kind of savings. Now you talk about savings. Have you declared correctly? And this is...
Sigur.
Da. Okay, then it wasn't savings. Now the question you talk about family savings.
Vorbim despre economiile familiei. După câte vedem, soția dumneavoastră a obținut 0 lei venit impozitabil în 2015.
Sorry, we lost the translation.
Something went wrong, I think.
I listen Romanian language, sorry. And I think you listen English.
In which year you said, lovely? In which year? About which?
We still talk about 2016. No, it's my channel is correct.
Now it should be okay. Yeah, indeed. Earlier I was on the English channel, sorry. And now I translated on the Romanian channel.
Yeah. The most important that... Do you have translation now?
Acum, la sfârșit, am auzit traducerea.
Yes, now in the end I heard the translation.
Da. Acum se vorbește în română, dar până acum s-au discutat în engleză. Nu doar început, doar acum 3.
Only this last question was first in English because I was on the English channel. Gata, s-a rezolvat, da. Eu eram pe canalul englez, acum deja am trecut la român și am tradus întrebarea în limba română.
Cred că n-am fost înțeles.
Yeah, I repeat the last question. You mentioned that you used your family savings. If we look the year, for example, 2015, when income of your wife was 0, taxable income. how you explain it?
Am explicat și dacă îmi
I have
permiteți să
explained it and I will
complet,
repeat it.
realitatea economică reflectă
The economic reality shows payments for 2016 covered with the balances that were left over out of the taken loans, the savings that have not been used up in 2015 and reported in 2016, but also there's been the salary savings from 2014 through 2015.
Okay, let's move on and let's talk about the year 2018. Here we talk about repair and furnishing expenses of a new apartment. And by our calculation, we see that in 2018, your outgoing financial flows may have exceeded your incoming financial flows by at least 303,186 leys, and we see that your income was 281,976, and at the same time we see expenses 585,162 leys. And we talk about apartment, and according to the reception certificate dated 27 of July 2017, you received ownership of apartment in Romana Street, yeah? And when your family moved into the apartment, you carried out the necessary repair and furnishing work. We see that it was white wall condition house. And according to answer number 11 from the second Rausum question, you mentioned that during 2018, approximately 90,000 lei was spent to the purchase of furniture and essential household appliances. But however, in the third round of question, when we asked to explain again where the money came from, we established inexplicable wealth for 2018. You stated that the expenses would have been approximately 40,000. Now, the first very simple question is 90,000, 40,000 or any other amount?
Da. Vă mulțumesc foarte frumos pentru oportunitatea.
Thank you very much for the opportunity to answer this question, honorable panel. I shall be very discreet when it comes to explaining these amounts because there were interpretations that were erroneous and incorrect in my opinion. So for 2018, my financial analysis shows a positive balance. All of the incoming and outgoing flows are fully legal, transparent, and documented. As for the difference, the 303,000 that was claimed by the Commission is the result, in my opinion, out of methodological errors when certain income was not taken into account, the savings were not properly correctly treated, and there was an arbitrary reevaluation not allowed by the law in this case, and some expenses were again erroneously counted. On the basis of my financial reporting for 2018, I have filed a declaration of assets where I have provided in great detail information, and I also provided to the Commission the contracts, the original contracts that were duly certified and registered with the competent public authorities, and there the value was stated as well in the contracts. Now, to the question of the Commission when I was asked, I've explained that the developer at that time registered the real estate assets that consisted of the storeroom, parking space, and the apartment for the amount that the developer thought it was relevant to sell those assets for. So it's about the right. It's the right of the entrepreneur or the developer was their right to decide what they wanted to sell that for. Unfortunately, there was a company, a limited liability company, was asked about the value of those assets in Chișinău municipality. Now, the expert, to answer the question of the commission, or rather I should say the person who provided the answer, because that was not an expert, but that person stated that we have to assess this asset and there has to be an expert that can perform such an assessment. Therefore, I believe that the actual prices that were paid by my family are the prices that have actually been put down in the sale and purchase agreements as reported to the NIA, and that has also, by the way, been checked by the NIA, verified.
Thank you, but still, I talk about your answers. And my simple question is, in second round questions, you talk about 90,000 was spent for purchase of furniture and essential household application. When in the same round questions, you indicated that the total expenditure amounted was approximately 250,000. We talk about your answers. And now in the third round of question, you talk about 40,000. We don't talk about our figures, we talk about your statements. How you explain it? What happened? 90,000, 250,000, and finally in the third round you talk about 40,000.
Da. Ca să fiu înțeles.
To make sure that I'm understood, the Commission has argued that one of the matters was renovations and furnishing for 90,000, as you've stated. That is 2018. However, the expenses spent over 2017 when the apartment was handed over, and all the way to 2019, so over 2 years. So approximately 60,000 lei were related to 2018 for the renovation works. Now the yearly focus, that total amount of 90,000, that was for a time span of 3 years. 2017, 2018, 2019, and that's why in the third round of questions in this regard I've explained that just about 60,000 lei were needed in 2018 to pay for the renovations works.
Mr. Țurcanu, could you say please now, what was the amount of money what you used for the apartment in this year, 2018?
Ce sumă a fost achitată pentru apartament?
The amount that I paid for the apartment? The amount of the apartment, the total amount
apartment
of the
for furniture, but it was white wall house. You needed furniture, you needed, What was the amount that you used in 2018? Again, I repeat, you have talked about 250,000, you have talked about 90,000, and you have talked about 40,000. My very simple question is, what is the correct amount? What you have used, really?
Honorable Madam, now to bring clarity around this amount and to avoid any circumstances that could lead to incorrect interpretations, I would like to underscore that the contracted amount for the interior works in 2018, that amounted to about 60,000 lei out of the total 90,000 that includes all the 3 years, 2017, 18, 19. Therefore, my final answer is that about 60,000 lei was spent in 2018. Thank you.
Thank you. Let's move on and let's talk about very good prices. If we talk about parking space and storeroom. As you know, the Commission examined the acquisition of your parking space with a total area of 38 square meters in Romana Street. And you declared the value of this property to NIA as 153,714 leis. But being asked about the low price of a real estate, you explained that actually you paid the 40,000 lei. And now my first question, because if we look the data and we see that from cadastre information, we see that in 2017 concluded 5 investment contracts at values ranging from 40,000 to 7,000 euros for similar properties, and the average price for neighboring parking spaces was 313 euros per square meters. And then we see your very good price. And my first question, what was the real price of a parking place you paid?
Thank you very much for this question. I will start off from the fact that
in the very beginning that we could be in the same infosphere. Just tell us what was the real price what you paid for the parking place. Just your answer, the number, please. Then we can move on.
Esteemed member of the Commission, Madam Lovely, indeed the amount paid by my family to the developer was considered of the amounts put down in the contract, in the procurement contract, in the purchase contract. And they were reported to the NIA and they had been verified. Now, replacing the contractual value without certain proofs and indicating a different amount at the suggestion of a company, I think that is not the place to claim this. What is more, to argue the price in order to avoid any doubts in terms of interpretation, I have filed an official interpellation request with the developer asking about the price setting at that date and what the price was for a square meter. According to the answer to the Commission, which is in the third round of questions and answers, so the Commission has received this official information from the developer, and the company has confirmed for the Commission that the prices would range between 40,000 and 128,333, which shows and proves the legal nature of the price that I have paid to this developer.
Thank you, but still, we know that you have explained that there wasn't any special treatment, and in what it was like you now describe, it was just a business. But again, I repeat the facts, and maybe you just could explain how it was possible that if we talk about market price, we talk about 235,000, 280,000. When we talk about the prices in the same building, we talk about 120,000, 150,000 lays, and now we talk about your price, and this is 40,000. How it was possible? What kind of conditions we talk about? How you got them?
If I paid close attention to the question, I would like to now quote the answer of the developer provided to my request. So they've stated, I shall quote, the prices were based on the location of the store rooms and where they are located, right around the corner, the square meters, and all of these factors. This has influenced the price. There was no preferential price or one that would be favorable to me. The developer explained in the answer provided to the Commission that the prices oscillated, varied between 40,000 and 128,000. Now, the same answer, just to be certain and to provide evidence, proofs to the Commission, I too have raised this question, and I was given an answer, and I have made that answer available to the Commission. It is not a price that I have set. It is the price of the developer on the basis of its economic and financial capacity at that date.
And very similar questions about storeroom in the same apartment, Romana Street. We talk about 4.4 square meter storeroom. And the situation is similar, that you talk about your price 50,000, and if we look the market price, when we see that the market price is 1,505 euros, how you explain the differences between your price and market price?
Esteemed member of the Commission, I shall reiterate the position that I have described earlier. At that date, that was the policy of the developer. Now, according to the answer of this company of the developer, the prices varied. They've also provided the range of the minimal one and the maximum amount. There is a range of prices that the developer was selling these assets for, and I have fallen within the range of the prices. The price was real, and what is more, the prices were set out in the sale and purchase agreements that were authenticated and registered with the authorities of the state in order for them to be duly registered and subject to taxation.
Thank you, and we can move on and talk about year 2023. And here we talk about inexplicable wealth, and we see that this balance is 66,460,000. And you have calculation in front of you, and we see that your total income, it was 867,000 lei, and at the same time your total expenses reached 933,907 lei. And Commission identified, as you see, several recurring or consistent categories of expenses incurred by you and your family members. And just when we talk about when the largest single expenditure was the purchase of a Lexus for 598,000. And my question about this year is, could you please explain again the source of income used to cover the negative balance? We talk about 66,460 leis.
Esteemed members of the Commission, the analysis for 2023, this financial difference, according to the calculations of the Commission, 66,460, that is not an actual deviation, that is not an actual discrepancy that would be indicative of the existence of inexplicable wealth as written in the law. But this is because there's an inconsistent application of the methodology for flows of money, and it's because of incorrect accounting treatment. This difference of 66,000, I must say 66,460, in relation to the income of my household, my income and my wife's income, that is less than 8% of the total amount of the annual flows, and that is under the materiality applied and used in financial analysis, in audits, considering standards that are the basis for that in practice. Such minor deviations are considered to be insignificant and not a reason to claim illicit enrichment. I would like to draw the attention of the Commission that all the income and expenses of my family for 2023, they are fully documented, verified, and they come from legal sources. One clarification that I must make now is that the Commission has raised a number of issues, a number of question marks. I would like to explain step by step every amount that requires attention and evidence. The Romanian child allowances, that is legal income that the Commission erroneously took out the calculations. I don't know why. I would like to explain and provide the following details. From 2019 through 2023, my younger son was being paid the child allowance provided by Romania. ING Bank Romania is the one through which we collected it. The account in the name of my son, there was this allowance, part of the income of the household, and that was meant for taking care of raising the child. Now, the payments can be supported by the Commission, given that he was a minor until August 2023 when he came of age. So in January to August 2023, for that period of time, he was being paid these allowances by Romania. Unfortunately, the Commission did not take those amounts into account, and it stated that given that no supporting documentation was provided in this regard, the Commission could not use those numbers. However, the payments were made, and they can be proven by historic statements of the National Agency for Payments and Social Inspection, that is a body in Romania. And this is also a matter of continuity of such flows in the previous years. Making some mathematical calculations, about 2,000 Romanian lei at that date, the exchange rate with the Moldovan lei, that would be 8,133 Moldovan lei. That's an amount that should be factored in. So the 66,000 difference that the Commission established at the end of 2023 minus this amount, if we subtracted, that would be about 58,000 in fact. So I don't know why the Commission did not factor this amount in. Next, the Commission has raised some issues with regards to vacation expenditure. The Commission has attributed this amount to be 70,000 as family expenditure, though I would like to draw the attention of the Commission to the next fact. In reality, in actuality, a big part of the costs were covered by my son, because reference was made to vacations to Denmark. One of my sons is studying in Denmark, and he is now employed in that country. As we had an anniversary of our family, there was the possibility to have a gift provided to me and my wife. So he covered some of the expenses, such as the airline tickets and other expenses. So a minimal prudential adjustment of 30%, about 21,000 lei, that would reflect the actual situation regarding this matter. As a general conclusion for 2023, following the correct application of the accounting and methodology principles, the year 2023 would turn into a balanced, positive year without actual discrepancies, and that will have all been covered with legal income. Therefore, there is no circumstance, none of the circumstances that are there allows one to claim that there is inexplicable wealth. Thank you.
Thank you. Maybe my colleagues, you have questions about inexplicable wealth when I continue with other topics.
Mr. Țurcanu, you mentioned earlier that some of the expense was incurred by your son in Denmark. How do you prove such expenses incurred by him? Mr. Chairperson, so these vacation expenses overestimated by the Commission. The Commission motivated this over 70,000 are family expenses. And I will repeat, with your permission, I would like to highlight the fact that an important part of the cost was covered by my son. This trip coincided with the anniversary, family anniversary. So the airplane tickets as well as other expenses indicated were paid by him. So this was an act done by him for the family and for myself. So that was a nice surprise for the family, because we had a celebration of 20 years anniversary. I accepted this invitation and I was pleased to visit him. But how do you prove them? Because I understand you haven't presented proof of the expenses incurred by your adult son. He spent these amounts from his own budget being employed, and I presented to the Honorable Commission the labor agreement of my son in Denmark and the expenses or the incomes for every year, including for that exact year. Therefore, his budget allowed him to make these small expenses, so symbolic amount, because this is not a significant amount. Discretionary, it was discretionary upon him to make these expenses. The rest of the expenses were covered by the family. So for me to understand, what you say is that there is no evidence that your son has incurred some expenses, but there are circumstances proving his capacity to incur such expenses. 30% that you mentioned, is that your estimation, subjective estimation? How could you confirm this? So the calculations made by me in accounting terms, given that 70,000, if we take the exemption of 30%, it would be 21,000 remaining for my family. So this reflects the real situation. Coming back to the situation described by you, I presented to the Commission and I proved with the details the income of my son, and I put in front of the Commission all the expenses, incoming and outgoing flows of my son from the Danish bank, which submitted that flow statement for my son.
Yes, Mr. Țurcanu, I have a question regarding savings. You may remember in the beginning of the interview by Madam Perling, you mentioned that you repaid 2 debts in 2015, 150,000 lei and 100,000 lei, using savings from 2014. Is that correct? Did I understand that correct? No. Okay.
Yes.
And you had borrowed these 2 amounts of money in 2014. And then I don't understand why you borrowed it, because apparently you had the savings to pay them back. Why did you borrow it?
Okay. Dear Mr. Irev, I will respond to this question. Actually, I did respond earlier, but to clarify regarding this position of yours. During 2009, from 2009 to 2014, being a judge at the Chișinău Court, I had some salary incomes. During that period of time, we didn't have any capital expenditures, no real estate, no land bought. So these savings were made by my family. In 2014, I concluded an agreement for a preferential price for which was provided to the judges and the civil servants in the system, because the procedures were not clear, and these installments had to be paid at different time intervals, in order for me to make sure that I will be able to pay the installments based on the savings that I had, because I didn't know how many installments I will have to pay. So I made a borrowing for 2014. Of course, part of the money I had myself. And after I made the payments for 2014, because the payments were one in August and one in October, in 2015 I paid back the debt from the incomes and savings made in the previous years.
Okay, that's clear now. Then another question. I understand that these are cash savings, because we didn't see any savings, sufficient savings on the bank, so it must be cash. How do you accumulate cash savings? How do you do it? Do you have a system for that?
No.
What kind of a system do you mean? What kind of system?
Do you have, let's say, a box in which you put money every week to save? Simple as that. Or does it work differently?
I hope I will be understood correctly. So the legal provisions before 2016, we didn't have to declare these cash savings. However, my household made savings because we didn't buy any luxurious property, in the prospect that we will later buy a real estate in order, because we had 2 minor children, so we wanted to have decent living conditions for those years. So the savings were made in cash by my family, so that afterwards, after we pay the installment, so that we can be able to pay the installments and all the other debts.
That's quite clear and completely understandable, but my question is, how did you do it? You got your salary as a judge and as a teacher on the bank, by bank transfers. So in fact you didn't have cash money. You made your expenses for your household, and then you created cash savings. How did you create those cash savings?
Okay, I will tell you, and thank you for this question. So aside from the fact that I'm a judge and I had a salary by wire, by bank wire, my main salary was at the court. The salary from the Academy of Economic Studies as a teacher, so it was also done by transfer. But during those years, 2009, 2014, I was also chairperson of the governmental committees, which were also paid. During that time, the money wasn't paid by bank transfer, but rather at the cash office of the universities, and the amounts were withdrawn, taken in cash. So these savings, or part of these savings, were based on those reserves made in those years. So I gathered those amounts in order to buy an apartment in the future.
Thank you for your answer.
Mr. Țurcanu, as a chairperson of the state committee, governmental committee, you mean the committees for organizing the examination at the graduation? Yeah, for bachelor, and other examinations at different universities, not just one university. I was invited to a different university as a teacher because I had experience. But this is not a permanent position. This is ad hoc just during the examination period. And from what you remember, what was the remuneration for the members of the state committee? Well, more than 15 years have passed since then, so I think whether it was 5,000 or 7,000, these were the amount for just one session of examination? Yes, because this was the text. So I was receiving that amount cash in hand at the Agrarian Agricultural University, State University, and other universities where I was invited, including the Sports University. But all these amounts were indicated in the wealth declaration and personal declaration. Personal interest declaration.
One other question. I just saw it. In one of your answers, you mentioned the income of your wife that was not declared. What kind of job did your wife have during those years?
What period of time? In 2023?
Verification, just the whole verification period. What kind of job or jobs did your wife have?
My wife, as a specialist, is a lawyer. And she also made some graduated some other education. She has a certificate in psychology, and she is now having a post-master degree at one of the university in Bucharest in psychology. She's a lawyer. She's employed now at the company Concordia as a psychologist.
And was she a psychologist in 2014 and 15 and 16, and was she employed then?
No.
No, she was
No.
not. When
She was a student at that time, and she was having her master degree. She was taking care of the children because they were minor.
And since when is she employed as a psychologist in Concordia?
2017.
Since 2017, 2018.
So 2017,
Acum, ca să nu vă duc în eroare, nu, ca să nu vă duc în eroare.
Well, not to mislead you, I think by the end of 2019 or beginning of 2020, but I can look in the as a declaration and I can tell you for sure.
I've seen her salary in 2023 from Concordia.
Da, e soție ce salariu.
That was my wife's salary.
Yeah. Okay, well, we can check the rest. Okay, thank you, Mr. Țurcanu.
Iată, dacă nu vă supărați.
If I may, just to clarify, my wife has a salary at Concordia. She worked as a psychologist at the Municipal Center for Rehabilitation of Children and also at the General Directorate for Protection of Child's Rights during those years, which is stipulated in this asset declaration.
My very last question about the inexplicable wealth, and you touched the Denmark trip, and you explained that your son paid for that. Through the 3 rounds of questions, you answered us that you have used cash savings. This is now here the first time when you talk about that your son paid for the trip. Why? Why you have not said it before? Yeah.
Honorable Commission, dear Mrs. Facilitator, in the 3rd round of questions, upon the question of the Commission, I explained that a part of the expenses were incurred by the members of my family. So I referred to my son, who is employed officially in Denmark.
Okay. Let's move on, and maybe you would like to add something about inexplicable wealth before we move on and start to talk about COVID allowances. You would like to add something? Yeah, please.
If you allow me, shortly to review about years 2015, 16, 18, 23 to which you referred. Given the explanations made by me today before you, the differences established for 2016, 18, 2023 are just methodological, minor and non-essential. There is no element, in my opinion, to indicate an unexplicable wealth or essential errors in this sense. I would like to also tell the Commission that all the patrimonial flows of myself and my members of the family have been documented, traceable, and they are in line with the legislation. That's why I'm kindly asking the panel, the Commission, that based on Law 252, to find the inexistence of unexplicable wealth, to reevaluate and the cancellation of the disbalances, and to reflect correctly the real financial flows in the final analysis exposed today in front of you.
Thank you. Let's talk about the issue regarding allocations and redistribution of COVID allowances. You know what we talk about. You have all the information in front of you. Just very shortly, we know that in November 2020, the leadership of the Chișinău District Court fully replaced the list of COVID-19 allowances beneficiaries, and it was previously approved by the SEM, and when the new list included you as the president of the court, who also shared the meeting, and in which was decided to modify the list. Is it correct? Yeah.
Da.
Okay.
Da.
And now we would like to understand what happened. My first question is, what, in your opinion, or I believe you know, what were the criteria that were taken into account in the initial list?
Da. Îmi permiteți să
Okay.
răspund?
Do you allow me to answer now?
Yes, please.
Da. Deci, onorată comisie,
So, Honorable Commission,
am ferma convinge că
I am firmly convinced that all those stated in this section, you will take into account the explanations made by me. Unfortunately, I never had a possibility to reflect this truth because, first of all, no one asked me publicly to do so, neither the media nor other public authorities. That's why I'm coming in front of you with the following explanations. First, indeed, during September, November 2020, the Chișinău Court, the biggest court in Moldova, which had over 700 staff members, was facing lots of COVID infections cases. During 2017 to 2021, I had a full mandate of president of the first newly created court, which included all the offices. As the leader, I had a legal and moral obligation to ensure equitable, fair distribution, documented distribution of the allowances provided in the government decision 731 of 2020. The original list received from SEM was incomplete and contained the staff member which didn't have any medical documents or who were on vacation. So to be more explicit, I will explain. At the end of October 2020, SEM asked in front of all the presidents of courts to present a list of people who got sick with COVID during exercise of their job, their office. Without drawing the attention of the president of the court, one of the offices, the Buiucani office of Chișinău Court, the deputy president didn't send this information in a centralized way to the president of the court in order to ensure that to make sure that everyone has the single answer before SEM. So it sent this list directly to SEM without taking into account the other opinions. Without knowing about this list, at the end of October or November, I was sued in court with an amount of 112,000 with a request to attribute this money. And one of the objectives of this list was to provide correctly these allowances to the people who got sick with COVID at their job places. So a committee was convened and they checked the list of all the legal documents for the provision of such amounts. Unfortunately, it was ascertained, found that a part of these employees weren't at their job in that period of time. They were on leave, on annual leave. Secondly, when it was asked to present the lists and the certificates for the COVID certificates or tests, some other people weren't able to present such certificates, such tests, because they didn't have them. And in order to make sure the payment, correct payment of this public money to those people, it was ruled to establish a committee created of deputy presidents, of course, in order to check the correctness of such lists. Therefore, it was established that Many of the people didn't have the right to receive such money, so we decided to take the formula of providing such financial support to the individuals who indeed were sick, and presented the proof of that, the certificates of those people who were intubated and really were hospitalized. That is why the amounts paid in the budget of the court, they were not nominal amounts, they were amounts per court, per different court. The vetting committee has this responsibility, because you interpolated the Ministry of Finance and the Ministry of Health for this issue. The rectification of the list was done within the budgetary limits which were approved, without exceeding the allotted amounts. Based on the law of public finance, and the rules of the Ministry of Finance, the leaders of the institutions were forced to use public funds according to their purpose and documentation, and I was led by those documents, and all the amendments were documented through the administrative orders 669 and 733 registered in the e-budget system, subject to the control of the Court of Accounts, and being also checked by the State Fiscal Service.
The committee also drew attention to the fact there was no conflict of interest. They've looked as to whether I was involved in a conflict of interest as regards those amounts.
Sorry, Mr. Țurcanu, but I asked the question and you didn't answer at all. My question is, if we talk about initial list, what kind of criteria were used that people put into the list? Do you know or no?
Yes, the criteria of legality, transparency, and fairness. These were the criteria that I had to deal with as a manager of financial resources.
Yes, you. But again, I talk about the list from SCM. Who created the list?
That list was provided by...
We talk about the first initial list.
The first list, the initial list, was submitted by the deputy chair of the Chișinău Court Boiocani office without informing the president of the Chișinău Court.
So, and you just mentioned that you have never had the possibility to give your explanation. As we know, this is public information that the criminal case has opened in this. Yes, so I believe you have had the possibilities to...
Sigur, da.
Okay, okay, then it's clear.
With the criminal investigation body, well, to that body I provided all the proofs. There is the presumption of innocence, the benefit of the doubt, but at the end of the day, the final order of the criminal investigation body was to quash the case, given that in my work as president of the court at that time, no elements of crime were found with my actions. And such a document remained in force, and it continues to have effect.
First list, it was done by a deputy of a court. You saw the list. You are chief of a court, you are president of a court. And you decided to modify the list. And you decided to put yourself into the list. My question is, did you ask from someone that the list is wrong, what should I do now? Or did you ask from someone that, this is quite clear, you are lawyer and we are lawyer here, but to put himself into the list, it doesn't seem very correct. Did you ask from someone that how to manage this situation?
Of course, and thank you very much for this very delicate question, and I will certainly answer it. In that period of time, I was in acting office in several headquarters. I was the president of the Chișinău Court, but on the basis of the Superior Council of Magistracy decision, which is also annexed to the materials, I was also appointed as deputy, and I was supposed to do those duties for Boiucani, for Centru, and for Rășcani offices, because the other deputies were away on a sick leave as they were sick. I too was diagnosed with COVID, and I have a valid medical certificate.
Sorry, Mr. Țurcanu, please, if I ask question, did you ask from someone some kind of advice, and you please answer to me yes, no, and yes, I ask from, and then just name me the situation, name of the institution, please. Please ask the questions.
The decision regarding my inclusion and of other colleagues on the list of beneficiaries, that decision was taken and signed off by the deputy chair of the court at that time. And therefore, I did not have a role in establishing the allowance for myself. He decided for an allowance to be given to me too, because I was away on sick leave, I had COVID, but also to other colleagues working in that office. Therefore, I explained I did not give myself that amount of money, but it was the decision, and it was at the discretion of the deputy chair of the court, who at that date was acting president.
Who signed the document? Who signed the new list?
The new list was signed by the deputy chair of the Chișinău Court Botanica office, who at that date was also having the position of president of the Chișinău Court. He was acting president of the Chișinău Court at that time.
Thank you. Did you participate in the meeting that the decision had done?
To the amendment of the list.
Yes.
Well, the amendment of the list, that was a collective decision, and there were deputy presidents, deputy chairs, heads of secretariat, accountants, and human resources from the Chișinău Court. As regards the attribution of the COVID allowance, well, I did not participate in the makeup of that list because I was not in the position of president at the time, because at that time the duties of that office were carried out by a different judge who was at that time acting president of the Chișinău Court. I have not participated in the compiling of that list. And I have explained. I have also submitted to the Commission those orders. The first one, whereby I decided the payments for all the other employees, and the second order that was signed by one of the deputies and also made available to the Commission.
We know that through evaluation, you stated during the rounds of questioning that the list transmitted by the SCM was informative, and you as president, you changed it. My question is first question, is there any official document supporting this interpretation that it was just informative? Yes or no? Because you have confirmed it several times.
Yes, and I would like to say that there is an answer of the Ministry of Finance in this regard. Initially, that was given to the SCM, but the Commission has it too, which confirms the fact that the list was handed over by the SCM for those amounts to be paid. The list was not a nominal one, but per court, 112,000 lei that was transferred from the SCM account to the account of the court for those amounts to be further distributed to people who have become sick with COVID at the workplace.
Maybe I lost the answer. Who or what kind of institution gave you interpretation that this is just the informative list? Just tell me the answer. Where do you take that it was informative list? Just.
The SCM has transferred to the account of the court that amount in order for the money to be redistributed further on, because the president of the court...
No, this is not answer. You have said this is informative. I ask from you, where do you take that it was informative? Who gave you that kind of interpretation?
prin răspunsul Ministerului Finanțelor.
Through the answer of the Ministry of Finance of the Republic of Moldova given to the SCM, and that can be found among the pieces of information that I have shared with the Commission. They stated that the management of funds, that is up to the manager of the institution, and the money is to be redistributed. As president of the court at that date, I decided for the money to be distributed to people who have had COVID, who got affected with COVID at the workplace. So this list, or these actions of mine, they have been verified by the criminal investigation body, the Anti-Corruption Prosecutor's Office. They have looked into the totality of records and lists and actions that I have undertaken at that time, and they've reached the conclusion that there were no elements of the crime.
Did you ask from SCM, because SCM sent you a list? Did you request some kind of clarification from the SCM in this regard before modifying the list yourself?
Yes, I have had a discussion with decision makers at the SCM, and that discussion was about the possibilities to properly manage those amounts. And after having had that discussion with the chair of the SCM at that time, so in that discussion I was explained that those amounts were to be paid only to people who have become sick with COVID at the workplace, and they were supposed to submit health certificate, medical certificates, and COVID tests, which is what I decided. So the people who were on the temporary list, who did not get sick with it at the workplace, who were on their paid annual leaves away. So imagine if I paid those amounts, it would have been a violation of the law. If I had given this money to people who became sick not at the workplace.
Where you take that kind of information, who got the illness in the workplace or who didn't? How you decided who are the 5 new members who to put into the list? Sorry, but you are not doctor, I'm not doctor, we are just lawyers. So please, could you tell us how you modified, what were criteria, how you guaranteed as a leader of a president transparency of a decision, and why the 5 new individuals? How you decided that there are some persons who didn't get the illness from work and there are someone who got the illness from the work? Could you please tell us?
Bineînțeles. Sigur. Onorat Comisie, vreau să vă spun la acest compartiment.
In this regard, as president at that time, I have filed an official interpellation with the Preventive Healthcare Center in Chișinău. So every person who was being tested for COVID, so every person would be checked, and thus there would be a personal record of every person with information like that. So we would ask for those forms or those records. We would establish if they have gotten ill at the workplace or outside of the workplace, at home or somewhere else. If they were not at work, for instance, they were not coming to work because they were away on a leave. A president of a court cannot provide an amount that was meant for people sick of COVID when one is on annual leave away from office, or maybe you're not on an annual leave, but you did not get sick at the workplace. Those records were swiftly submitted to the criminal investigation body to check their legality, and that information is found among the materials and the official answers from the doctors responsible in this regard. That information can be found in the case file that is archived with the criminal investigation body. We did not take this out of thin air. The official position was provided by specialist doctors. They provided information and everything required. There was a social inquiry made by the general physician into the situation of the person who had gotten ill, and then that information was analyzed so as to make it then available to the criminal investigation body. And all of this work was undertaken for me in order to provide the competent bodies with authentic, genuine information.
But as I understand, Mr. Țurcanu, you have signed an order appointing 5 new individuals. Is it correct?
No.
No, okay, it's not correct. Did you participate in the meeting where was done the decision to modify the list or no? Yes or no, please?
Yes, I participated. However, the decision was collective to amend it. There was an administrative meeting in order to ensure fair treatment for all.
Okay. How was the decision to amend the list communicated to the excluded individuals, and were they got some kind of opportunity to challenge this decision?
First of all, I have asked these people to provide medical certificates and the COVID test. If they didn't have such documentation, the commission established that they didn't have COVID tests, they didn't have any medical certificates. Therefore, the commission amended the list. And I repeat, the funds were distributed to people who have actually been severely sick, who were admitted and intubated in hospital. So with swiftness, it was them who the funds were attributed because they needed this help. These people were, of course, informed, and some of them withdrew from the list. They knew they were away on a leave and they couldn't have been on the list because the government decision was very specific and clear that the beneficiaries can only be those who got sick at the workplace. If you got sick when you were on your annual leave, you can't get that payment.
If you participated in the meeting, why you didn't sign the list? You just say that I said that I see you signed the 5 new individuals. You say no. I asked, but why not? Why you, if you saw that this is not fair, why you didn't sign as a president of a court this new list?
I might have been misunderstood, so I will reiterate. I have signed the list for a part of the employees when I was exercising the duties. That was for people who were sick with COVID. An administrative order was issued to this effect. A different administrative order was signed by a different person, by the deputy chair of the court. As I was on a sick leave, I couldn't have exercised some leadership duties, and in my absence, those duties were fulfilled by the deputy chair. That was for the order of redistribution to other people was signed by him, not by me, which is proven to the commission because those orders were shared with the commission. And in the evaluation case file, these orders can also be found.
Would you like to ask some question about the COVID?
Yes, I have one question. Who was the deputy or the vice president acting at that moment?
At that date, the deputy president of the Chișinău Court Central Office, performing interim duties, that was the judge Vitalie Stratan. The order was signed by him precisely. Thank you.
Domnul Țurcan, haideți să facem așa o...
Mr. Țurcanu, I would like to ask you a couple of short questions. Also, please be brief in your answers without explanations. Yes, no, or who precisely and who did what, to make sure we have clarity. We remember, we can recall the circumstances of the COVID pandemic. We know about those requirements or people in public office who take the infection at work. This is widely known. This is not up for discussion. But let's go back to the Chișinău Court and what has gone down there. There was a request from the SEM to all courts for the courts to provide the list of people working in the court who have been infected with a virus at the workplace. Now, that request was sent to the Chișinău Court, to the central office or to all of the offices. That request came to the central office, to the name of the president of the court, to collect information from the other offices. At that time, you were the president. Yes, I was not acting president. I was the actual president of the Chișinău Court at that time. How did it come around that a deputy president from one of the offices, in a way that is, well, let me not call it abusive, but in a way that, I mean, how, with such a request, they could have done what they did? Well, as I stated that as a president, all deputies from all offices were supposed to check the list of employees and to provide the needed information, as it was natural for one single document to exist. There is one list covering all offices. So I get you right. As president in office, you've asked the deputies from different headquarters, from different offices, to prepare each of their own list for their offices, yes, and then they would be centralized in a single one document that we would share with the SCM. And instead of giving that to you, one of the offices did that, sent that to the SCM directly, and the SCM approved that list as if it was the list for the Chișinău Court. Yes, because, well, there were some other courts too, not all of them, but some of them, there was very little time. Till the evening you were supposed to file it. So from other offices of the Chișinău Court have sent that individually? No, only in a centralized fashion. But then we sent officially one single list, but the Buiucani office had already sent their own list. Understood. So when the SCM approved the list that the Buiucani office sent, you have reassessed the situation and then you sent a new list covering the entire Chișinău Court. The SCM had received the list. The list was not nominal. The amount of money... Wait a second, a short answer. The SCM approved a list. When you say the list was not nominal, what do you mean? I mean, there was a list of people. And or was it just number of people? It was number of people. For instance, 1 million from the account of the SCM to Chișinău Court, 112,000 for 17 people. So the Buiucani office did not send a list of people. Yes, ABCD. A list of people, yes. Now, what was the criteria to select the people? What documents were supposed to be annexed? That was not submitted. So are we getting it right when you say? You are saying that the people on that list did not meet the criteria of the law. They were not eligible as per the criteria of the law. That is, they hadn't become infected at the workplace. Yes, correct. Later, afterwards, you established a commission or a committee and you reassessed that. And on the new list, you've included only the people who've managed to prove that they met the criteria. That is absolutely correct. And I'd just like to make one single clarification. On the new list, we had people from all of the offices, 1 or 2 persons per office on the basis of eligibility criteria, transparency, medical certificate, COVID test. And the last question, somebody from the list from Buiucani, were they on the other list? Yes, in the first list that I signed, there were some people from there. The other people were excluded because they did not have certificates and because they were on their annual leaves. Because, all right, that information was already stated. Thank you.
Thank you. And let's take the last issue regarding the salary supplements, and there are 3 sub-issues. 2 different versions, regulations, the second bonus system, unclear bonus system, and the third questions about duties related to classified information. But let's start from the very beginning. The Commission, we received 2 different versions of regulation on the granting of performance bonuses from the Chișinău District Court. Is it true or no? How do you explain the existence of 2 different versions of the same regulation approved by the same order, number 52, with different content?
Îmi permiteți să răspund?
Yes, please.
Allow me to answer.
Onorată Comisie, justificarea legalității și corectitudinii.
Justification of the lawfulness and the correctness is based on the following aspects.
Existența unui singur regulament.
The existence of a single applicable regulation. I will draw the attention of the Commission that during that period of time there was just one single official regulation approved by Order number 52 of 2018, communicated to the staff and submitted to the control bodies. The regulation number 2 referred to by the Commission, pretended regulation, was never applied. I haven't known about it, I wasn't aware about it, and in my activity I relied on one regulation, the one approved by order and signed by me with the holograph signature. At managerial level, there were no parallel documents during my activity period as a president, and all decisions about salary bonuses were done according to the official regulation. About the existence of the pretended regulation number 2, I found out from the commission, and I understood that this is under criminal investigation, an analysis of the actions of some people from the court about their activity.
Sorry, again I lost. My question is, again, very simple. We see two different regulations. And as I understand, you answer that there are only one. Is it correct? Yes?
Eu m-am condus doar de un singur regulament.
I relied on just one regulation.
Okay, but how you explain that your signature is on both versions of regulation?
Încă o dată explic.
I'll explain again to the Commission. I would like to be understood correctly.
În calitatea mea de
As the president of a court, I signed just one order which was approved, by which the regulation was approved. During my activity period, I relied and I was guided by just one regulation.
un alt regulament.
About another regulation, I wasn't aware. All the more, if you allow me to make a reference, during my activity, I was checked by the Financial Inspection, Court of Account, Judicial Administration, and they didn't found any other regulation. There wasn't any other regulation. There was just one regulation. I wasn't aware of any second other regulation.
But now you have heard already several times that there are two. Have you already reported that maybe it's crime, maybe it's false document?
Nu am raportat.
No, I haven't reported because during my activity I relied on a different regulation. My mandate of court expired in 2021. Now we are in 2025. Therefore, if whether there was or not, my signature was forged or the existence of any other regulation, I wasn't aware of that.
Okay. Then let's talk about bonus system. If we look the bonus system regulation, there are different kind of people and different kind of rates for bonuses, and it's absolutely okay. My question is, what specific criteria were applied in the repeated designation of the same individuals to internal commissions, for example? Because this is huge court, I understand it's important to keep some kind of criteria. What kind of criteria you used? But to give to the people the possibility to participate in the internal commission and pay for that some kind of bonuses.
Thank you very much for this question. With regards to the lawfulness of the performance bonuses or salary bonuses, I would draw the attention of the Commission that the single regulation stipulated the objective criteria for providing such bonuses, particularly productivity, involvement in administrative activities, and participation in internal commissions or committees. So these eligibility criteria were these were relying on this criteria.
Thank you. And as you mentioned, there were hundreds of people in your court, and I believe a lot of charges. was there some kind of objective mechanism what you used that to understand that the productivity and competences and what you just mentioned, but that kind of criteria are really applied? Objective mechanism, how it worked, who decided, or how it would build up?
Thank you very much. Well, the threshold, legal threshold, was 10% from the fund of basic salaries, which wasn't exceeded by me as a manager of the court. I would remark that the attribution of the amounts was done based on the proposals of the heads of sections rather than the personal decision of the president. Internal commissions that you referred to, they were established, convened transparently through official orders with the annual rotation in order to have a bigger number of judges in there and also other staff members. And the activity of the members is documented in reports and official notices. You should know that I provided such premiums, bonuses for all these employees, starting from guardians and the cleaning staff and the judges and all, over 700 people at that date. I'd like to also draw your attention that all these official controls, audits, we were checked by the Court of Accounts, Financial Inspectorate, Agency for Judicial Administration, which confirmed the correctness of the economic and financial activity. As a conclusion to your question, the bonuses provided were legal, proportional, and justified in accordance with the provisions of Article 16 of Law 270 on the unitary system for salaries in the budgetary system. Thank you.
But what about for people? Was it similar treatment? Or were there some kind of differences? And you personally, as president of a court, decided or made the final decision?
Honorable Commission, if you mean about the favoring some staff members, I will answer the following. Repetitive naming of some staff members in commissions was motivated by the technical specificity of the activities, the evaluation of the logistics commission, procurement commission, security, information, IT, and so on. The activity of such commission was documented and archived in the court. No financial control or no audit hasn't identified any unlawfulness regarding the opportunity and lawfulness of this payment. So this was done based on the available budget and based on 10% of the salary funds existing at that time. There were no favored people, individuals. All the decisions were made according to the institutional procedures established. Thank you.
Okay, and very final topic, this is bonuses for activities involving classified documents. According to referral submitted by the judicial inspector, there are serious discrepancies were identified in the awarding of bonuses for activity involving classified documents. And we see that there are some persons who receive monthly bonuses during this time, and at the same time, and they don't act in this area, and at the same time, the individuals actually performing activities in this domain didn't receive the bonuses. So please, could you explain how it was possible and how you explain that the bonuses to individuals who didn't have that kind of responsibilities, they got and they didn't?
Dear Mrs. Facilitator, regarding the bonuses for classified information, according to Law 245 of 2008, the verification of eligibility belongs to the Service for Information and Security and the security officer, which is competent for checking these people. So these people were checked, and there was a positive agreement to to provide the right to these people to the state secret. After that, these people were awarded this mandate. Provision of such bonuses were done based on the proposals motivated done by the heads of divisions, and no person which wasn't authorized didn't benefit from such bonuses. And documents attached in the third round of questions, for me, confirms that all the payments were legal, documented, and proportional. And as a conclusion for the Commission, I didn't have a direct role in establishing the eligibility, and I didn't favor any staff members in that respect. Thank you.
Thank you. No more question from my side.
Mr. Țurcanu, would you like to make a short statement before the conclusion of this hearing? Yes, of course, Mr. President, if you allow me, with regard to my ethics and integrity in this aspect. Managerial activity of me during the reference period during 2017 to 2021, the entire mandate was done in line with the law, respecting the integrity, transparency, and equity criteria towards my colleagues. I didn't obtain any personal benefit, and I didn't favor any staff members. Everyone were equal before the law. The administrative offenses, the judicial inspector confirmed, and I provided the records for that. In the end, I kindly asked the Commission to establish that providing the salary bonuses was proportional without affecting the conformity and criteria for evaluation. Mr. President, this is what I wanted to tell you as a final conclusion with regard to the ethics and integrity. At the end, if you allow me, dear members of the Commission, honorable attendants, I'd like to sincerely thank you for the opportunity to speak in the conclusion of this hearing. The vetting process for me was more than just a verification. It was a sincerity exercise and a reflection on my entire professional and personal pathway. And I firmly believe that through this kind of evaluations, the confidence of the citizens into justice is strengthened, and this improves the attitudes. During the 18 years of activity as a magistrate, I exercised my profession with dignity, balance, and respect towards the law and the people. And I never had any conviction at the European Court of Human Rights during that period of time, and neither disciplinary procedures finalized with sanctions. I provided to the Commission my entire transparency, being convinced that the truth doesn't need artifices, just clarity and the good faith. I would like to bring thanks to my family, which supported me unconditionally, my parents, who through their tacit confidence, and my colleagues who helped me to collect all the needed information. At the end, I would like to say that I'm looking at this stage with the calm and the respect. Regardless of the results, I will stay dedicated to the belief that justice should be clean, fair, and humane. Thank you sincerely for your attention. We also thank you. Now we are at the end of the hearing today. Thank you, Mr. Țurcanu, for your statement and the answers to the questions. Following the hearing, our panel will have an evaluation report which will assess whether the subject meets the ethical and financial integrity based on the law 252, and the panel will make efforts to finalize the report and to announce its conclusions as soon as possible. I declare this hearing closed.